Good morning, ladies and gentlemen. Today is August 26, 2021, and this is the regularly scheduled meeting of the Municipality of Anchorage Board of Adjustment. The first item on the agenda, I'm Bernd Gucho, the chair, I should mention. The first item is to call the roll. Madam Clerk, would you please call the roll?
Yes, Mr. Chair. Mr. Gucho.
Here.
Mr. Deep.
Here.
Mr. Stewart.
Here.
You have a quorum, Mr. Chair.
Thank you so much. The next item we need to look at is the agenda, which the clerk very kindly prepared for us. Would you take a look at that, please? And see if there are any additions, deletions, corrections that you wish to make. Mr.
No,
Deep?
I just moved to approve.
Okay, has been moved. Mr. Stewart, I assume you're seconding that?
Second.
Okay. Any discussion regarding the approval of the agenda as it is before us? Seeing none, Madam Clerk, would you call the roll, please?
Who did that?
Mr. Gucho.
Yes?
Mr. Deep.
Present.
No? Yes. You need to vote yes for the agenda.
I was gonna yes. When you said roll call, so I did do that one.
Okay,
in the
all right.
beginning. So, anyways, yes, it's a big yes.
Mr. Stewart?
Yes.
Thank you. The agenda has been approved. Next item, as we're rapidly going through here, is that we need to look at the draft minutes of the June 29 meeting of this board and see if there are any additions, deletions, or corrections, or whether we can simply approve those minutes. Mr. Deek, any additions, corrections?
No, Mr. Chair, this is concise and seems to represent what we have accomplished.
Thank you. Mr. Stewart?
I see no changes necessary.
Okay, neither do I, and there being unanimous agreement, the minutes of June 29, 2021 of this board are approved. Next item is old business. I'm not aware of any old business. Is anybody aware of any old business? Mr. Stewart?
No, I'm not.
Mr. Deek?
No.
All right. Zipping then right along to what really will consume the most time here today is under new business. There were two requests filed to relax the procedural rules. One filed by Joan Priestley et al. And the other one filed by Sean Tomokowski. And there has been extensive briefing on this, and I hope that we are prepared to discuss those items now. In order to move this forward, first of all, since there are two requests, I think we need to deal with each request separately, and I propose that we deal first with Joan Priestley's request that was apparently joined by various other people as well. And so I will entertain a motion to relax the procedural rules as requested by Joan Priestley et al.
Mr. Chair, I move to approve as stated.
Thank you, Mr. Deek. Mr. Stewart, are you going to second?
Second.
Okay. All right. Any discussion, Mr. Deek?
Yes. We need some discussion before we, of course, get to the decisions on this one.
Well, we are. The motion is on the table,
Yes.
and so we are going to discuss the request.
Yes, so
the
that's-
motion is to approve the request
Correct.
by Joan Priestley et al.
Yes. So that was kind of the opener because I would like to have that discussion now and proceed forward. And the first item on that one is that it would be helpful for me at least to have a little support from council about the idea of the statement which was made by this appeal, or like a request rather, to relax the rules, which was stating that the there was an appeal filed after our action, and that appeal is not on our agenda yet, or has been not discussed on our agenda. And I wonder, how does that truly relate to our proceedings if after this process is concluded? That's one question. And the other question is, it would be helpful to know what are the procedural steps after any decisions today for in terms of this decision being appealed, and what happens with the actual decision by the planning board, the original decision. If you could help us with that a little bit, that would be good for discussion.
Mr. Wheeler, I failed to mention at the introduction that the board counsel, Mr. Wheeler, is present, as is the clerk, and in addition to that, there are various members of the public, both here in person, present, as well as by telephone. Mr. Wheeler, can you address the two questions posed by Mr. Deek?
Mr. Chairman, Mr. Deek, to your first question, if I understand it correctly, you're asking about the status of these appeals, or any appeal, related to whether or not you grant or deny the motion.
Correct.
Okay. So, as noted in the clerk's letter of July 20, at that point, only Tomokowski had filed a notice of appeal, which is a prerequisite to getting the matter before the board. So if you were to grant Priestley's request, you would be effectively allowing that group to submit their notice of appeal late. And then that would trigger the process by which they would ensure that the record, if not already completed, got done, the transcript, if not completed, got done, and then the briefing cycle would start.
As far as the reference from the original, we're going to have to find the citation here, the request to the Board of Adjustment to relax rules, there was a reference in the discussions here that talks about a motion for reconsideration and appeals under 2020-2 and 2020-3. This is I guess the crucial argument in this request for the idea of tolling, and we don't really have any kind of information to tell us whether what's the relationship between that process and what we are doing today.
So Priestley seems to be making the argument that, similar to court rules in Alaska, if there's a motion filed, that motion can toll the time period for some related filing, right? So in this case, their argument is that because there was a motion for reconsideration filed, that told the time period for them to file their notice of appeal. I don't personally agree with that perspective, but for a number of reasons. One, this board, to the best of my knowledge, has not issued a decision saying it would follow that particular court rule. Number one, and number two, I don't think the two are necessarily related in the same way that the court rule was related, because that motion was in a different pathway, if you will, right? Because it related to two prior appeals and not the appeal that we were expecting to see after the planning board's February 3rd hearing.
Thank you. And then that's helpful. And then if you could address the second question related to the process for this proceeding, and what are the rules after a decision has been made here, as far as appeals and how it affects the original decision we made during the previous meeting.
To the chair, Mr. Tomas, Mr. Diak, I think the question you're asking is, if you issue an order in this case, what happens next, right? So if you issue an order in this case, then theoretically either party may have the opportunity to appeal that order. Is that
Yeah, correct.
Is your question.
What I'm more interested to know is that how does that affect the actual case which we have acted on previously,
Right.
and it is obviously it is a planning case, and the appeal could be only directed to the decision about the request to relax procedural rules, not regarding the actual case, which was the original case to decide on during the previous meeting. So the question here is about this parallel path for a procedural and a land use based decision.
If you grant either of the two requests, then the underlying appeal will move forward. If you deny both requests, there is no appeal before the board.
Thank you.
Mr. Deek, you made the motion. Are you prepared to state at this point whether you are in favor or opposed to the motion? Or whether you wish to delay your decision until you've heard more argument?
Well, actually, it would be probably helpful to have everyone, well, the second to speak to it, but I have formulated an approach to this, and what I heard confirms my belief that I will not support the motion to relax the rules based on the precedents and the information we have in front of us today in terms of us having a certain way of acting based on the land use code, and that procedural step would create a precedent which, in my view, is not desired.
Thank you, Mr. Deek. Mr. Stewart?
Yes, I noticed in the Priestley motion that it really should have been filed by June 8th. And I think that's where the relaxation of her request would go back to. So we compare June 8th with the time when they actually filed, which would be 13 August. The letter's dated 12 August, or the motion is dated 12 August, but it actually was filed on the 13th. What I'd like to see is each one of those filings, when they do come in, that they're stamped so that we've got both dates, both the date that it was written and the date that it was filed at the clerk's office. So I think that's part of the procedural issue is where would it go back to? It would stem for what was required by that June 8th deadline. That's where they would go back and reapply. I think one of the things that is a bit misplaced is the appellant's assumption that the tolling was according to the Alaska court rules. And it seems to me like if the Alaska court rules were to be followed, they would still require timely filed motions. They have to be done in good faith, and there has to be just a good cause to justify granting the motion. And the other thing is that they're normally looking at the short delays, which are before the deadline, on the deadline, and shortly after the deadline. So I think when you look at the good faith, there ought to be some action that is fairly close to that deadline. In this case, we've got a little over around 2 months before any action was filed. The one thing that I see also in here is while the appellants have filed pro se, I do look at the exhibits and I see considerable experience and familiarity with the code provisions. And I think that I think basically if we do this, we're taking the statute and we're overreaching where I think our statute intended to go. So with that in mind, based on the facts and the record before us, I think the appellant's assumption that the time was told, I think it appears unreasonable and that it does not show sufficient support to justify good cause findings.
So how do you intend to vote on the pending motion, which is to approve the request by Joan Priestley et al.?
I intend to vote against the motion.
Thank you, Mr. Stewart. I wish to speak up on this matter as well. I'm opposed to the motion and I intend to vote against it. And my reasoning for that is as follows. Priestley et al. Based their request on AMC 2103-050A9, which provides that on timely application and for good cause shown, the Board of Adjustment may relax or modify procedural rules for the orderly transaction of appeals before the board. Now, she has a twofold argument. The first one is that because there was a motion for reconsideration pending, that told the appeal period. Well, my response to that is there's nothing in the code or in the procedural history of this case to state or to affirm that view by Ms. Priestley. It is in fact not told. The appeal period is not told. And consequently, we are exactly where the clerk in her letter of July 20 states we are, which is there's no appeal pending at the present time. So I reject the argument that she thought that because that there was an honest error on her part, that she believed there was tolling. In fact, there is no tolling, and consequently, I reject that view and that reasoning. The second one that she bases her request on, she says, if there's no, in essence, she says, if there's no tolling, then relaxation for good cause it should be granted. But the law favors relaxation only if there's good faith, no prejudice, and a short delay. I do not see that there's a good faith explanation here for the delay. She has not shown that. We have, in terms of no prejudice, there is in fact prejudice here, and that is to Holtquist. They have been delayed for many months here, and it appears to me that there is no good reason to grant the requested relief on that basis. Also, there's not a short delay, as Mr. Stewart stated. There's a 2-month delay here. We need to, these cases, and we are charged as a board with, and the parties are charged with proceeding diligently and in such a manner that applications and appeals can be disposed of in a timely manner. Here, Ms. Priestley waited more than 2 months before making the request for relaxation of the rules, and I do not find that to constitute a short delay. So for all of these reasons, I intend to vote against the motion. There's something else I want to say about this, and that is that in my view, the perfection of an appeal is not procedural. That is substantive. And if you do not comply with the appeal rules that have been set forth in the code, I do not believe that this board has the authority to suddenly create an appeal that didn't exist before. If there is to be a relaxation of the appeal rules all by itself, that needs to happen via amendment to the code. There is no provision in the code right now to relax substantive rules, and this is a substantive rule that requires perfection. And so for that reason alone, I'm not in favor of granting the relief requested by Ms. Priestley at all, and therefore I intend to vote against the motion. Having been somewhat long-winded about this, I'm wondering if my fellow board members have any additional comments regarding the pending motion, which is to approve and grant the relief requested by Joan Priestley et al. Mr. Deek, anything further you wish to add?
Do not have anything further.
Mr. Stewart?
The other thing that I'd like to reiterate is that in the code regarding the clerk's responsibility, it's mandated. It speaks in terms of mandatory rejection if these particular requirements are not met. The transcript was not provided. The clerk had no other alternative, and I think the code is pretty clear, is that the clerk shall reject that particular case in front of her, which she did. And I think with that mandatory language in there, I don't think that we are an appeal authority for that particular juncture.
Yes.
Yes.
I should mention that Mr. Wheeler reminded me of that. What you really did was you addressed Mr. Tomokowski's argument in case, which was that he failed to file a
Oh, I'm
particular
sorry.
required
You're right,
document.
I did.
Anyway, we are on the motion, and the motion that is pending right now concerns the request by Ms. Priestley et al. To allow her to perfect the appeal, which she failed to do by the June 8th deadline. Do you have anything else that you wish to address?
No.
Regarding that motion? Okay. All right, I have nothing further, and Madam Clerk, if we are prepared to vote, if you would call the roll, please.
Yes, Mr. Chair. Mr. Buchak?
No.
Mr. Deek?
No?
Mr. Stewart?
No.
The motion fails by a vote of 0 to 3. We then come to the request of Mr. Tomokowski to allow the late filing, to waive the procedural rules regarding the filing of the transcript that is required by code to perfect the appeal. And I will entertain, or maybe I should simply make a motion so that we get this before us and can discuss it. I will move that the Board of Adjustment waive the procedural rules requested by Sean Tomokowski regarding the filing or the provision of a transcript in a timely manner. May I have a second, please?
Yes, Mr. Chair, I second.
Thank you. Give me a second here. All right, we come then to a discussion of Mr. Tomokowski's motion, and since I am the one who made the motion, I will discuss it first. I intend to vote against the motion, and its argument is that the failure to provide a transcript in a timely manner was an honest mistake of the procedural rules. But when you look at his argument in greater detail, what you find really is that this was a strategic decision, and he even admits this, It was a strategic decision not to comply with the rules in a timely manner. So his explanation does not constitute good cause as far as I'm concerned. Again, the clerk is required to reject the appeal if the transcript is not filed in a timely manner. This is mandatory. This is not discretionary. And so, since it is a prerequisite to perfecting the appeal, I do not think that this board has the authority to relax that requirement. If we were to simply grant the request, we would effectively gut the rule, because then every time that a party does not comply with it, it simply may or can file a motion to waive the rule, and we would then be bound to consider that, and it would in essence abrogate the provision of the ordinance which requires the appeal to be perfected in a particular manner. He says he didn't think the filing was necessary. Well, that points out the strategic decision that he made. He should have contacted somebody. He should have contacted a lawyer of his choice who knows something about this area of the law. But to simply proceed as if he knows, and he takes the chance that he may be wrong. And in this case, I believe he simply is wrong. So it is for that reason that I do not believe that we should sanction a false strategic decision by a party. And it is for that reason that I intend to vote against the motion. Mr. Deek.
Yes, thank you, Mr. Chair. There is, on this particular case, there is one element which is, as much as it's clear in the code what the obligations of the clerk are, but this issue you point out about the dialogue or the correspondence or contact with the office. It's evident with the office advising Mr. Tomokowski about the quality of the documents he sent in, not in terms of what's in them, but in terms of what is legible. Now that dialogue is getting to a point where I confess, I don't have to confess, I'm not a lawyer, but this is one of those arguments that there's no statement in the code about whether copies should be legible when you submit them, but we assume that that's probably a good idea for us to be processing them. Now that issue that the clerk actually did engage on that particular level seems to be one of the arguments made by Mr. Tomokowski, and I concur with your statement that the other issue about on the same level to see whether that transcript truly needs to be filed rather than just having the minutes and the decision provided as the evidence of that being the transcript or a substitute to the transcript. I don't think it's a strong enough argument for us to relax the procedural rules on this particular case, and that's where it lies to me in this particular case, and that's why I will vote against it.
Thank you, Mr. Deek. Mr. Stewart.
To piggyback on what Mr. Deek said, the clerk is there not to provide legal advice to appellees or appellants. That's not the clerk's purpose. And as the chair mentioned, if they're going to get advice, they need to be seeking it from someone that is schooled or up to date on what the rules and regulations are. As I looked through the information that Mr. Tomokowski provided, it seems like he was trying to shift the burden of responsibility to the clerk when he was talking about the incident that Mr. Deek just described. But that same thing is also talking, he tried several times. One time referring to the Holquist should have filed it if there was something in there that would help their case. So it's kind of it's almost a reverse reflection on what he was trying to say. And in relation to the late filed transcript option, the appellant said the clerk did not ask for or specify anything related to the late transcript. And again, he had already filed two transcripts, which he relied on, and he's saying no communication from the clerk specifying all is well confused him. I think what is happening here is this is an attempt to overextend the scope and go beyond the standards of timeliness and for cause envisioned in the statute. So I intend to vote against this motion.
Thank you, Mr. Stewart. I have no further discussion or comments regarding the motion that I made, which was to relax the procedural and waive the procedural rules as requested by John Tomokowski. Anything further, Mr. Deek?
Nothing further.
Mr. Stewart?
No.
Madam Clerk, I think we are ready to vote on this matter.
Mr. Buchak?
No.
Mr. Deek?
No.
Mr. Stewart?
No.
The record needs to reflect that the motion fails by a vote of 0 to 3. The only thing left to discuss at this point, since both motions have been denied, is we will, of course, have to meet again very briefly to prove the decision that we reached today. And there needs to be, and I want to remind the clerk that I believe there needs to be mention made that the parties have 30 days to appeal this matter to the Superior Court. I believe that's appropriate, is it not, Madam Clerk? I work with you. Maybe I'm catching you flat-footed on this, but it appears to me that the parties, since it's an adverse decision to them, need to be able to go to the Superior Court if they wish and litigate this matter.
Through the chair, I think that's something that you're going to need to discuss with board counsel. In the letter of June 20th, it stated there that there may be a right to appeal. I'm not sure if this is a final decision of the board that is appealable, but I think Mr. Wheeler will be able to sort that out for you.
Well, thank you, Mr. Wheeler. Before you respond, it is my view, and I would suspect my fellow board members will support me in this, since this is really a final decision, in essence, that it ought to be appealable to the Superior Court. But maybe you have a more legal view of this matter than I do.
Mr. Chair, may I jump in on,
Yes.
on that? I think maybe I have been not 100% clear on my question previously, but that it is exactly what I would like to also have
Okay.
the council.
All right. Mr. Stewart, before we let Mr. Wheeler respond, do you have
there's-
anything to
yeah,
add?
There's one point in here, and that is this decision then would involve tolling of the rest of the case.
No, it doesn't toll
Or
it.
does it affect?
No, it doesn't
Okay.
toll it. Mr.
Let's
Wheeler.
listen. Let's hear it from counsel.
Would you address this?
Mr. Chairman, it'll be in the order, but no, yeah, I agree with you, sir, that this is a final decision, and that the parties will have the ability to appeal. To Mr. Stewart's point, there is no pending matter, right, as indicated in the clerk's letter, there is no appeal. You've confirmed that the parties then put obligations to perfect their appeals and file what they needed to file. So you've finally determined that, yes, in fact, there is nothing related to this particular planning case that's left before this board. And so the parties are free to appeal your decision that makes that clear.
So what you're saying is this is the final disposition of this particular case?
That is correct.
Including the decision, Mr. Chair, if I may, including the decision of the previous month, which was basically why this whole discussion came up afterwards.
Correct.
Thank you.
Anything further regarding this matter, Mr. Deek, Mr. Stewart?
No.
I have nothing further. Okay then, we move to item 6B. And the reason that I asked the clerk to put this on the agenda is there are two other appeals that are winding their way through the process. One of them concerns Spruce Terrace subdivision and the other one concerns Turtle Hills. And you have the case number, the appeal numbers there. Former is 21-2 and the latter is 21-3. Now, there are the board presently consists of 4 members. There is Nancy Pease, there's Mr. Deek, there's Mr. Stewart, and there's myself. Nancy Pease and I have terms that do not expire for a bit. Can't remember the exact dates, but that's really immaterial. But there are 2 terms that are expiring, or the terms of 2 board members that are expiring, and that's Mr. Deek and Mr. Stewart. Now, as chair, I would like to hear from those 2 whether they intend to follow the practice before this board and before other boards of the municipality, which is to serve out the term regarding pending cases. Because if the answer is we are out of here tomorrow or in October, we know that these appeals are not going to be finished by October. So if you take the position that you are no longer going to participate in those pending appeals, the board is in a pickle, as it were, because there are only 2 remaining board members, and we cannot consider and conduct business with just 2 people. So I need to hear from you, Mr. Deek first, and then Mr. Stewart, whether you intend to participate in those 2 pending appeals. And I'm not addressing conflicts of interest.
Right.
Okay? That has nothing to do with it. There may or may not be conflicts. I do not know. And that has not raised its head yet, and we don't need to address it. I'm simply interested in hearing from you whether you're willing to participate in the process and see these 2 appeals to the end. Mr. Deek.
Yes, thank you. In addition to your prowess as a lawyer, I would give you the prowess as a marketing genius. But as far as the rules go, being on boards, chairing other boards, the procedures are actually stating in the code that you as a member have a code required, or I don't know if it's required, but a code allowed extension of your term. And so even if we have not been reappointed with the interest that we would like to be, there is a grace period under which we can proceed. So to answer the question, I will intend to do, first of all, I have not made a decision. I intend to continue on with the code allowed time extension as it's written, and I also intend to see out any of the cases if I'm on the panel to bring them to a conclusion. I think it's it's basically our duty to make sure that the timely processing of these cases are taking place, and I intend to be a supportive person of that.
Well, thank you, Mr. Deek. I very much appreciate that. You know that I have been a chair of this board for quite a while, and I take this very seriously, and I'm interested in timely dispositions of pending appeals. We owe that to the parties.
Yes.
Mr. Stewart, what is your view of the matter?
I have a question for the clerk, and that is, can I, or counsel, can your extension be variable and tied to particular cases that are before the board? Because I would not, I do not intend to
You're not going to
go for
re-up.
another 3 years.
Yes, I understand that.
But if we're going to be handling a case, we still have to be beyond, like for us, October 31st, we still have to be considered commission members. And to do that, don't we need some sort of documentation that would say we are still members, or can we serve without reappointment?
Mr. Wheeler?
Mr. Chairman, Mr. Stewart, I'll need to confer with the clerk, look at the code, but I want to say there was some time limit on that.
Yes.
Contingent, was it 90 days?
I believe it's 90 days. It could be as much as 120 days.
Yeah.
Yeah.
I have to look at the code, but it's either 90 or 120.
Right, so I guess the worst scenario would be you start on a case and then we have to transfer that to somebody else, because then in theory, that person would need to listen to any hearings and read all the briefing and try to get up to speed.
In other words, what you're saying is, and I'm sorry to interrupt, what you're saying is, if 120 days expire and the appeals are not taken care of, there's no way to extend it.
Not to my knowledge.
Okay.
Because I don't believe that there is anything built into the code that would allow yet a further extension.
Madam Clerk, is that your understanding as well?
I believe so. I think there is the possibility for the board to continue on as a 2-member panel. If one of the members had to, I see from the chair that that's not desirable, but I think there is that possibility as well.
Okay.
Mr. Chair, if I may, again,
Yes.
just based on experience, I have not encountered yet any of the boards I've been a part of where when the vacations, when the time limit which is allowed by code is expiring, you have to have the seats filled by assembly action, and then those seats go vacant. So the person no longer is an appointed member of the board. So we have the option of hurry up and finish in that time period, or we're going to have somebody else to take over the case. That's how I read it, but obviously, again, I'm not a legal mind on this one.
Okay, thank you. Mr. Stewart, does that answer your concern?
Well,
What you've heard you?
is it reasonable to assume that we can dispose of these cases within 120 days after October 31st?
Well, I would hope so.
That's what I would hope. With that in mind, yes, I intend to carry on and go through and complete the action on these two cases that we've got before us now.
Okay. All right. There can, of course, be no guarantee that we're finishing this within
No, I
120 days
understand.
of your time limit, which I believe is the end of October, is it not? So we
I
are
think
talking.
it's October 14th, Mr. Chair.
Okay.
14.
Yeah, mid-October.
Okay.
14th.
So it's
So
November,
January.
December, January, so we're talking about either January or February 14th.
And I will say that the first case, Mr. Chair, first appeal 2021-2 is already in we should be receiving the first brief within the next, I believe, 10 days. So it's well on its way to getting to the board. The other one is brand new.
Okay.
And Jen, Ms. Clerk, I do, if I may,
Yes.
I do want to know that I believe, I have the recollection that the 21-2 is already constricted by Ms. P's conflict of interest, if I believe.
I believe that is the case.
So that is basically putting us in a position that we know who the panel is, if there is
Yes.
one.
Yes, yes. Okay. All right, anything further regarding the matter that's on the agenda as item 6B? Capital. Hearing none, we then proceed to, I think, any member comments? Anything, Mr. Deek, you wish to state, Ed, at this point?
No, I think this will cover it, and I suppose we'll hear, or probably hear soon enough about the cases as we move
Okay,
forward.
thank you. Mr. Stewart, any comments you wish to make?
No.
No comments by Mr. Stewart, no comments by myself. So we are then proceeding to item number 8, and that relates to audience participation. And there may in fact be somebody left on the telephone. I don't know, there's nobody left here in person, but if there are persons on the telephone who wish to participate at this point, I need to caution them that they may not discuss or talk about adjudicatory matters before this board. Pursuant to AMC 2103-050-A10B, the Board of Adjustment shall not hear argument nor take additional testimony or other evidence. The Board of Adjustment may consider only the material contained in the appeal packet. So, having said all that and cautioned, is there any member of the audience who wishes to address us? Hearing none, we then are ready to adjourn, I believe, and if there is no objection from any board member, I will simply move that we are adjourned. Hearing none from board members, this matter is now adjourned.